implicate his life and will have an effect on the society. Since we are social animals, our choice does not impact us alone. It impacts our society, the community we live in. Which is why we are proposing that through this bill we will give choice not only to the individual but also to the society. Finally, to emphasize that this is a balancing exercise between the society and atomistic individual decision making, and this does not amount to complete taking away of their personhood or their ability to make choice forever. Rather than it is just restricting their ability to make mistakes which are quote plainly absurd. Okay, thank you.
So to begin with, even though we do agree that decisions that individuals take are influenced largely by the society they're in and their environment, the ultimate decision that they take is still an individual one. It is just influenced by society. And what this bill seems to be doing, at least to us, is taking away that individual's decision-making right. Now, side proposition did say that, okay, so we're going to try splitting this bill or the wording of section 1 into multiple parts and seeing why it's problematic, each portion of it. They addressed the very first sentence. They spoke about cannot express their own will, and they did speak about plainly absurd. We agree with them that when it comes to comatose patients or unconscious individuals or people who are completely incapable of making a decision for themselves, we really can't, this might be a good idea. But if we look at the wording of the provision, it says cannot express their will. And as we have seen historically or traditionally, we've looked at expressing one's will as being known to and being knowable to society at large. This could, so as long as proposition restricts this only to those sorts of individuals, it might be acceptable to the opposition here. But if this were to go any further, say you equate this to individuals who can't express themselves in public, or individuals who can't speak, or intellectually disabled individuals of some sort, that is problematic and that cannot be covered under this definition. Let's look at the terms plainly absurd. The proposition didn't really define this word. They seem to go with the flow of the act that they had put forth. It's extremely vague as a standard. It doesn't seem to explain what could constitute absurdness in these circumstances. You also have to account for things like power dynamics. For example, if someone is making a decision and there is another person in their lives who is possibly more has some sort of authority or wields some sort of power over these individuals, they could walk up to court and put forth a petition saying their will is absurd. And you're going to test that will against, I presume, the morals or values or standards of the time. What you believe, as side proposition said, correct rational choice. And correct rational choice will obviously come from one moral standpoint or one value system. And it does infringe on individual liberty in that sense. So a better definition for the phrase would be welcome. Let's look at the phrase close enough to share the person's personhood. How do we determine who is close enough? Uh, there is no evidentiary standard that seems to have been put forth in this regard. And a point that we just like to make here is, though we might believe we know a lot about a certain person, no one really knows everything about everyone, including my mother about me. So there may still be some things about me that people do not know. So at what point do you say they know enough to be making decisions about the other person, right? And one more point that my team happened to bring forth, after which I give you the mic, is if you're going to be allowing people to file these petitions before a district court, there should also be a provision in place that ensures that the district court very strictly scrutinizes these applications to make sure there is no vested interest that is involved when this petition is being put forth. So that's really important, because we have seen that in a lot of cases, economic interests have played a very important part in trying to undermine somebody's will. So we have to guard against that zealously.
All right. Right. So let's talk about if a person can't express their will. So in terms of people who are unconscious or otherwise unable to express their will, unless you really want to wake them up by giving them stimulant so they can sign that surgery form, we completely concede that. So from the first, if someone can't express their will, the feminists have been arguing that we have to reconfigure personal autonomy in ways so that we can address the rights and do justice to those people who find it difficult to express their will. So let's look at it in terms of people who are sort of intellectually disabled, all right? And I'd just like to remind you that it's a feminist claim that we have to do this in inclusive and enabling ways. So let's say advocacy is necessary. Someone close to you, like a family or caregiver who shares your personhood, we do need them to make these decisions for you, but you have to stop focusing so much on your care ethics and your interdependence, because you're neglecting the importance of maintaining the distinctness of individual self. You pass this law and things will escalate, and I'll tell you why. Because then those people who share this personhood can become oppressive and dominating and start dehumanizing you. You're essentially stripping away that human self from the person who's unable to express their will. It's only when you can see the person who's incapable of expressing their will without help as an autonomous being, completely able to make valid claims, and you can only claim to act in their support, that's when this actually becomes valid, because you need to support their ability to make decisions. You're supposed to assist them in expressing their desires, to make legitimate decisions, and to sort of give face to the value of their decisions. This thing you're doing where you're simply giving them the ability to countermand the decisions that someone who's unable to express it properly, then you're making it even more oppressive than it was before, because now they have the ability to do what they think is best for you, which I'd like to remind you again is the entire opposite of what this feminist proposition lies on, which is supposed to be inclusive, not exclusive. So taking this now into the district court and giving them this legal blanket power to countermand, what exactly are you trying to do? Remove the ability of these people to make a legitimate decision? Because you yourself are an individual capable of expressing your will. And if the will of the one who can't express their claim lies in contrast with yours because you just simply don't like it, what's stopping you from exercising this power given to you at will? So this is just sort of taking the social narrative of blame already on the disadvantage and running away with it. You're making it worse. A person who can't express their will, you're supposed to help them, not substitute your decision for them, because you have that ability.
Well, that was a pretty methodical deconstruction of your bill. Do you have anything to say in response?
Just to start with the criticism about vague definitions, about definitions like plainly observed, close enough, not being properly defined.
So about the definition here being problematic of the words plainly absurd, and about how we've had many such definitions that are vague and undefined and have worked perfectly. We're not really asking for an exhaustive list of situations where something would be termed plainly absurd. Even mere indicators or pointers saying these are the kinds of circumstances, a non-exhaustive list of circumstances or pointers would also be indicative and helpful, especially because of the example that was given. And I'd like to thank him for the example, because I was thinking of what example I could give to prove my point. But let's look at a situation where a child, an adult, a 19-year-old boy comes up to his parents and says, I want to join the ISIS. Is he not exercising his cognitive ability to make a decision? It's not possibly a decision in his best interests as we would think as a society. And it is not. It's not the right thing to do, but he is still making that choice as an individual. You don't need this act to prevent him from joining the ISIS. His parents could still go and say file a complaint saying maybe we know he's going to go ahead and do something, say criminal, or the state might have an interest in preventing him as a sovereign so as not to engage in terrorism. There are a lot of other things that could kick in. And that's the same thing with all of these provisions that you just spoke about, things like undue influence or the Mental Capacity Act or anything else that discusses these sorts of standards that regulate people who can't possibly express their will. There is enough in place to help or stop people who are still making right decisions but are morally possibly incorrect. Right because it's a cognitively discerned decision, but wrong because the values of the time don't think it's the right decision to be making. And I think that distinction is important to understand in this context. And if we keep a definition this wide, we're giving the judiciary great scope for overreach, and this is a problem we've made through the times. Yes, at different points in time, the judiciary could be pro-people or pro-government, as we've seen in our history itself. And you can't leave it to them and give them such a wide playing field to determine at what point they think something is right or something is wrong, given the political, say, climate of that time and how they'd want to make a decision in that situation.
Yeah, like she said, that ISIS point is a very good point. So let's take it to the opposite spectrum. Suppose there's someone who's 23 but intellectually disabled, let's say, and they say, oh, I want to go to Disneyland, right? Disneyland. I want to go to Disneyland because or it's something even stupider, because he's 6 years old in his head and his parents are like, oh no, you can't make decisions for yourself. I have to make this decision for you. And it's obvious we can't go there, because in their head they're thinking about the costs, they're thinking about a variety of other things, but on the face of it they can just reject your claim, your desire offhand. Now, I don't know about that. And one more thing. Are you really going to go to a district court and say, oh, my son wants to join ISIS, I don't think you should let him? The kind of questions that are going to go to the district court, I don't know what kind of questions are going to come up in front of them. You're just opening a can of worms for any kind of thing to go up there. So are you just saying that any expression of will that you want to countermand or something that's not clear to you, you're going to take it to the district court? Really?
The question here is not one of whether you have an identity which is shaped by others, but whether you have an identity of yourself at all. It could be shaped by others, but that does not mean that you cease to retain your individuality, and that is precisely what you're seeking to do here. So unless you resolve this dichotomy between the societal identity and this shared personhood, you will not be able to come up with a solution which respects the autonomy of the individual as a person himself, which cannot be given up.
No, so no comparison like yesterday, but just I think they were able to look at it from a lawyer's angle, that the way in which you are using the word will here appears to be a pervasively vague term as opposed to an open textured term. So maybe in order to have a more sharper discussion, we could have possibly used the word will as in willing property. That would have been a far more tangible example for us to have a debate on. But if we do take on board the concerns which the opposition is raising, you're essentially trying to question the ability to represent somebody else or to substitute somebody else's judgment for yours, which is a fairly valid sort of argument to make on its own. But once again, if we connect it back to our threads from the previous day's discussion, aren't we actually doing that even for people where there may not be any argument about not being able to express your will? So it's not just a question of the extreme possibility of a youngster wanting to go and join the ISIS or somebody wanting to blow up all their savings. But as a routine also, are we not as citizens or members of institutions repeatedly allowing others to express or at least act on our behalf? So that could possibly be an idea which can cut the other way around as well. Right? I mean, aren't we already kind of working in a framework of shared personhood whenever we participate in institutional life or associative life? So it's simply a question of acknowledging it at a higher degree when it comes to individuals who may be otherwise be unable to explicitly indicate their preferences. So I think we should possibly take the idea of shared personhood as a far more routinized, far more sort of status quoist claim rather than something that we need to legislate or explicitly bring upon. So I suppose maybe the legislation is infructuous for that reason. So there's something to be said for both sides again. Right?
Thank you, Chief Commissioner. So one of the interesting things is in legislation on mental capacity, supported decision making, which we'll be looking at tomorrow, we actually use the term will and preference. And the fascinating thing is that's a contradiction from the get-go, because will is something that presumably emanates from impulse, a little bit like, you know, the primitive side of your brain kicking in. Whereas preference is redolent of sifting the evidence, rationally working your way through. So it's actually quite a contradictory term, but most people just use it as a term of art to really mean just the choices of the person. Are we sure it's actually coming from the person? But then that begs the question, is the person normally distributed? And can we hold him or an image of him or her and then use that almost as a proxy or a valid substitute for the absence of the person at a particular moment in time? I think the answer is probably not, because you really are on a slippery slope there. But let's take it up again tomorrow, because particularly the first limb of this, person who can't express their will and preference, comes up again tomorrow. And one of the justifications for supported decision making, even in cases where the person is, for example, in a persistent vegetative state, is that he or her and their autobiography is held by others. They have privileged access to who you are. Of course, they may abuse that access too. And even when they don't intend to abuse that access, they might even unselfconsciously be substituting their conception of what's right for you from your authentic voice, whatever that happens to be. So I think you deserve a round of applause for each other. It's not often the government applauds the opposition and vice versa. So we're going to take up with the disability issue tomorrow, which is kind of a hard case, because we're thinking about people in extreme circumstances, possibly with no autobiography. So you can't actually just pick up the trace elements and put them all together. Possibly in extreme isolation, with no opportunity for social interaction. Remember, Bruce Hood said, and Damasio said, the brain is primarily a social instrument. If it's not activated in that context, it basically decays, right? So it's no surprise, therefore, that they lack both the competence and the confidence to actually make their own choices in life. Nevertheless, the the support paradigm is said to kick in. And that's what I want Amita to justify tomorrow, and perhaps draw her out a bit. What does she make of this support concept, and how does she overlay onto that conceptions of shared personhood, or does she overlay onto it conceptions of shared personhood? And then we're moving on to the rights question mark of animals. What is their legal status? What are the arguments to be made? If, for example, we stick with the Kantian fixation on cognition, we've got to admit many of them have a lot of cognitive ability. If we're looking at empathy, we've got to admit a lot of them exhibit empathy toward at least their species. And then, once we've done our complete survey of the concept of personhood and some of the traditional boundary problems, then we move on to the hard one, which is enhanced humans. So enjoy the evening, and see you tomorrow. I apologize, we're working through the weekend, but that's the way the course is structured.